Bar Council of India leads us to a conclusion that these are adequate powers with the Bar Council of India under the said Act to provide for such norms and rules. We are thus of the view that while considering the question referred to us, the only conclusion which can be laid is that the interdict placed by the judgment of this court and V. Sudhir on the powers of Bar Council of India cannot be sustained, and we cannot hold that V. Sudhir lays down the correct position of law. The effect of the view expressed by us would be that it is left to the Bar Council of India as to at what stage the All India Bar examination has to be held, pre or post. There are consequences, especially in respect of the interregnum period, which would arise in holding the All India Bar examination in either scenario. And it is not for this court to delve into them, but it is for the appropriate to leave the Bar Council of India to look into the niceties of both the situations. However, in view of the larger ramifications, we do consider appropriate to delve into some, though not all, the aspects which may get involved in holding the All India Bar examination, especially in view of some suggestions made by the amicus. We may take note of the fact that the All India Bar examination is scheduled held twice a year. It is necessary that should be strictly followed. Otherwise, the law degrees would be left with idly. The All India Bar examination. In India, the various recognized institutions provide law degree, often declares result at different time. It takes time. We are inclined to accept the suggestion from the learned amicus that the students who have cleared all examinations to be eligible to pursue the final semester of the final year course of law, on production of proof of the same, could be allowed to take the All India Bar examination. The result of All India Bar examination would be subject to the person passing all the components of the college examination. More often than not, there will be hiatus period between the date of passing the examination from law university and date of enrollment. The eligibility of a law graduate to perform certain tasks may thus arise. Suggestion made is that during period between the date of passing the examination and date of enrollment, any graduate with degree who will get to appear for the bar examination or get enrolled under the said act should be able to do all tasks allied to the legal profession other than the function of acting or pleading before the court. We give our imprimatur to the suggestion. Another issue which arises is the seniority at the bar. This is relevant for many purposes, etc. We said. We must also note that Bar Council of India has the power to make rules determining the seniority amongst advocates under 49(1)(a). The amicus suggested that unlimited attempts to pass the All India Bar would not be in line with the scheme proposed by the court, and it should be limited to any number of attempts which the court deems fit. We would, of our own, hesitate to prescribe the number of opportunities available to a law graduate to take the exam. In case of pre-enrollment examination, the period of 2 years between the enrollment and passing is already specified. Then learned amicus also sought to flag the issue of persons who may take up other jobs and may want to enroll themselves as advocates later. This aspect we've discussed under section 49(1)(h). We are inclined to accept this suggestion in principle that the appropriate rule can be framed laying down that an enrolled advocate who takes up employment in a non-legal context for substantial length, say for 5 years, would be deemed to be a new enrollee, and in order to regain qualification, that person would be required to take the All India Bar examination once more. We believe the requirement of an active legal practice and that of an unconnected job are different. Even if a person has a law degree enrollment, it does not mean that his ability to assist the court would continue with him if there are a long hiatus period of time in some unconnected job. The other two suggestions made by the London amicus are the validity of the results obtained by any candidate in any pre-enrollment or post-enrollment examination must be limited by time, which would be policy matter for the Bar Council to consider. We also have one caveat arising from the plea that different state bar councils are charging different fees for enrollment. This is something which needs the attention of the Bar Council of India, which is not devoid of the powers to see that a uniform pattern is observed and the fee does not become oppressive at the threshold of the young students to enter. While we agree in principle with the suggestion of the learned amicus that they should receive attention of the Bar Council urgently in the process of steps to be taken in view of the judgment, we will note that the contra viewpoint sought to be suggested before us, predicated on the judgment of V. Sudhir case and view of opinion, same would not be good law. Our hope is that the aforesaid observations, while conferring a great role of Bar Council of India, would make the Bar Council of India more conscious of the importance of the role it has to perform, including ensuring that only persons who are well equipped with tools of law pass the All India Bar exam. Further, in view of periodic changes in legal position and consequent nature of All India Bar examinations being held, we like to make this judgment prospectively applicable so that it does not disturb the scenario which have prevailed during interim. We clarify that the setting aside of the judgment when we Sudhir is in no manner in imprimatur to mandating the requirement of pre-enrollment training. We expect the Bar Council of India to take necessary steps within a period of 3 months. In the end, we hope that our view would assist in bringing forth enrollment of young bright minds at the bar who would be able to assist the court in more efficient manner so that administration of justice is benefited. Civil appeal and petitions are disposed of, leaving parties to bear.
Right, Lord.
So, unanimous opinion of all the 5 judges.
Thank you, Microsoft.
To the amicus.
Thanks for the opportunity.
Anna is sitting next to him. That side is also very long. Okay. Say that. जब वो साइन कर ले
ये दिखा देना एक बार
जी
अपलोड करने से पहले
हाँ जी
मैंने अपलोडेड
ठीक है
थैंक यू
We have held that the decision of the Constitutional Bench in the case of Sina requires reconsideration. We have recorded reasons why it needs reconsideration, and there are 2 grounds on which we have said that requires reconsideration. In paragraph 32, we have said that to conclude prima facie, we find that the exercise of balancing the rights under Article 26B with other rights under Part 3, and in particular Article 21, was not undertaken by the Constitutional Bench in the case of Sardar Sayedna. The question is substantially an issue before the bench of 9 judges in Supreme Court review 9 judges. Moreover, the question whether the protection can be given by Article 26B to the practice of excommunication is to be tested on the touchstone of the concept of constitutional morality as it is subject to morality. This is an important and emergent issue. These are the 2 main grounds on which the said decision may need reconsideration by a larger bench. Then we have said that these 2 issues are covered question number 3 and 4 framed by the 9-judge bench. And therefore, we have requested the Chief Justice to tag this matter along with the 9-judge bench.
Thank you. I'm done.
No, sir. That's good.
That's it. We were expecting 9.
You will have to argue it.
So that's it.
It'll come due
क्या बता
course.
आज जुलाई में
3 years. 2 years.